All right, good afternoon. It is Tuesday, April 2nd, 2024. This is Criminal Justice Full Committee. If you're looking for civil government or civil justice, you're in the wrong room. So this is your chance to leave. Otherwise, if you're staying, we're glad you're here. Madam Clerk, please take the roll.
Representatives Carringer, Davis, Doggett, Farmer, Fritz, Glenn, Hardaway, Howell, Johnson, Lamberth, Moody, Russell, Towns, Vice Chairman Gillespie, Chairman Holsey. Mr. Chairman, you have a quorum.
Thank you very much. Members, do you have any personal orders? Yes, Representative Glenn. Oh, no, that's Towns. Sorry. I can't tell.
He's better looking. Mr. Chairman, the members, I'll do it again on the House floor, but I hate to have to do this, but many of you all probably work with Judd Matheny. I don't know, but I know there's several around here that did work with Judd. Great guy, member of law enforcement, just a fantastic guy. He used to do a thing every year for us on the military base. Okay, fantastic thing where all the members come, Senate, House, and he left and ran for Congress and ended up becoming the mayor, newly elected mayor. And unfortunately, they found Judd dead in his home probably a few hours ago. Okay, but he was a swell guy, just a swell guy, you know. And so he was only 53 too, just a young man, you know. And if those that don't know him, you missed a treasure. Those that do know him, you knew a treasure. So, in this meeting, Mr. Chairman, I'd like to have just a moment of silence for our friend, our colleague, Judd Matheny.
Indeed.
Amen. Thank you.
Any other personal orders? Representative Hardaway.
Thank you, Chairman, and I just feel obligated to amen everything that Representative Towns just said. Judd was just a good guy. He was a good man, and I had the pleasure of working with him. We shared a love for German Shepherd dogs, and he had one of the most beautiful black shepherds that you would ever see, and it was well trained. And then he would bring it with him to work quite often. But I just want to, once again, amen what everything that Joe said. Judd was a friend. We'll miss him.
All right, any other personal orders? All right, that leads us to our calendar today, and for the committee, item number 16, which is House Bill 2509, is off notice. And item number 19, which is House Bill 2681, is off notice. Which now brings us to item 1, which is House Bill 0688 by Representative Hardaway. Did I hear a motion? Motion and a second. Do you have 2 amendments, sir?
Motion on amendment 014985.
We have a motion. Is there a second? There's a second on 014985. All those in favor say aye.
Aye.
Opposed, no. Ayes have it. That amendment is on your bill, sir.
My co-sponsor. Deeply appreciative. This bill is designed to set up a frame of mind that I think we just need to start calling stuff what it is. And community terrorism is what we're having to endure in our society today. From criminal gang activity, I didn't say gangs, I said criminal gang activity that's designed to intimidate the people in certain communities and force them to accommodate the criminal gang activity that these criminal gangs wage. And I'm emphasizing criminal gangs because I've heard and had discussions on gangs versus criminal gangs. Our law enforcement has identified the criteria for criminal gangs, and so it's not a question of whether you are or you aren't. This bill would enhance the penalties for those who do drive-by shootings, those who are, and I'm going through the criminal gang activity. It could be prostitution, it could be drug sales, et cetera. But we've got to call it what it is, and it is criminal gang activity. And Mr. Chairman, one of the features that I was surprised when I found out that we didn't have it in law is you can do a drive-by shooting and then go get your driver's license renewed. Doesn't make sense to me. I would think that that's a basic common sense move that we need to make. So with that, Mr. Chairman, and in recognition of time, I'll ask for an affirmative vote by my committee.
Okay, are there questions for the sponsor of the bill? Representative Johnson.
Thank you, Mr. Chairman. So you're saying after they do their time, they'll lose their driver's license for 5 years?
There's a 5-year period that will kick in, and during that 5-year period, if they need to have a license for going to work or going to church or going to school or something of that nature, they can petition the court for that special driver's license.
So this is after I mean, my assumption is they're going to do time. And so it's after they get out, then it's 5 years? Is that correct?
Yes, ma'am.
Okay, thank you.
Other questions for the sponsor of the bill? Oop, can you back up one question? I have a question. Thank you, sir. Reckless endangerment is what keys all this in. It's kind of the trigger for it, if I'm reading it right.
Yes, sir.
And once reckless endangerment's triggered in, then all these other offenses would apply if they were done. There's a section by a school, by a library, by a rec center, by a park, by a daycare. And that jumps the felony up to a C if a deadly weapon is used in that. Am I reading that correct?
Yes, sir.
Okay, one other question. If one person did this and they're not running with anybody else, a gang, 2 or 3 or 4 or 5, just one person, would they get this same enhancement?
Well, Mr. Chairman, they could be the one person if they were part of the criminal gang and they were carrying out criminal gang activity. The linchpin here is criminal gang and criminal gang activity.
Representative Johnson.
Thank you, Mr. Chair. So one thing I forgot, if they can't have a driver's license, if they've done what they needed to do, can they get a state ID to vote after they've done their time, if everything else is covered?
This does not address that.
I just don't know what legally, if you can't
Well-
get a license, you might be able to get a state ID. I just don't know what the law is.
Yeah, I would have no objection to them having the state ID. So I'll make sure that my legislative intent is expressed there.
Thank you.
We expressly said driver's license in the language.
Okay, any other questions for the sponsor? I have one more. If there's one person committing a crime near a library, let's say, what mechanism do you use to prove that it's gang activity versus just an individual committing this crime of reckless endangerment?
Mr. Chairman, that would be the investigation that's done by law enforcement and the DA. So we're not taking away the prosecutorial discretion on this.
Okay, any other questions for the sponsor? All right, did you ask for a roll call vote? Did I hear that right? Or did I make that up, or did I dream it? Okay, well, I'm glad. I didn't want to do one anyway, all right. All right. We're voting on House Bill 0688. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. Moves on, sir, to Finance, Ways and Means.
Thank you, Chairman. Thank you, committee members. Mr. Chairman,
Go ahead.
even though that bill is gone, I want to send my condolences and my congratulations out to Reverend Clemmy Livingston. He was a preacher that was shot in front of his church just by stepping outside when there was a car theft going on. He was able to return to the pulpit on this past Easter Sunday, and he delivered quite a sermon. As you can imagine, he was inspired, but he's the kind of citizen that this bill was inspired by. Thank you, sir.
Thank you. All right, item 2, which is House Bill 2898 by Chairman Kumar. You got a motion and a second. Chairman, you're recognized. You have an amendment, I see.
Yes, Mr. Chairman, it is 017203.
203, that's what I have. Motion and a second? Motion and a second. We're voting on Amendment 017203 to be attached to House Bill 2898. All those in favor say aye. Opposed, no. Ayes have it. Amendments on. Proceed, sir.
Thank you, Mr. Chairman. This bill is the result of a tragedy in our community a little over 2 years ago. And that is why it is named as Savannah's Law. Savannah was a young lady in her early 20s who, after finishing school, started work at the sheriff's office in administration. She was well-liked and a pleasant young lady. Family lived in our community and still does. Over a period of time, she started dating a fellow who she detected had a bit of a violent tendency to him. She considered getting a court order, but before she got around to that, things got off hand one evening, and although he was not supposed to be around there, he came and parked his truck in her driveway. He stayed there, did not leave. She became concerned and called the sheriff's department where she worked, and the people knew her. Before the sheriff's people were able to get there, the fellow had shot Savannah 9 times and burned the house. This really shocked our community, as you can see in a small area, how that would be when we know each other. It also turns out that this fellow had a previous record. And I've had the honor of working with Savannah's mother at the hospital, where I practiced for 40 plus years. And after having gotten their life together and their feelings under reasonable control, Mom approached me that if there had been a domestic violence registry, Savannah was sophisticated, knowing law enforcement well enough that this problem could have been prevented. And this is the reason for us, House Bill 2898, to establish domestic violent offender registry. It will be on a graduated scale. For a person to be listed in this registry, it would be a repeat offense, not the first offense. It'll be a repeat offense. And then they would be listed for a number of years, for 2 years for the second offense, and then subsequently graduating to 5 and 10 years. Our hope is that this would make people aware, and this would prevent for future tragedies. With that, Mr. Chairman, I'm here to answer any questions.
Okay, you've heard the bill. Questions for the sponsor? Question been called for. We're voting on House Bill 2898 as amended. All those in favor say aye. Opposed, no. Ayes have it, sir. Moves on to Finance, Ways and Means.
Thank you, Mr. Chairman. and
Thank you,
committee.
sir. I have to apologize to Representative Dixie. I had told you that I would get you at the front of the calendar since you were rolled last week. So if we will go out of order and take item 14, which is House Bill 2417. Got a motion? Got a second? You are recognized, sir.
Thank you, but I'm sure you and GA's relationship was had some kind of influence on me getting pushed down. But anyway, we've we've had this bill up. I think we've been here for 3 weeks now. So I'm not, unless anybody has any questions or refresher of what I'm trying to do here, I can answer them. But all I'm trying to do is whatever people's doing from post 96, this just moves it back to 1986. I'm not asking for anything different, any type of special treatment, asking any other special type of relationships that would make it easier for them to get their constitutional rights back. It's just all I'm trying to do is give them a uniform playing field that is already out there and just extending it back.
Okay, Leader Lambert.
Thank you, Mr. Chairman. I had an amendment that I had tendered. I shared with the sponsor. It would not have been considered a friendly amendment. It's not an amendment that the sponsor would like on his bill. I respect that, but with that, I would make a motion to send this to a summer study. Mr. Chairman.
We've got a motion and a second. Yes, sir.
And Mr. Chairman, I want to mention to the sponsor, there's been 5 or 6 different sponsors that have had bills that deal with this area. In my humble opinion, this thing has been chopped up to 5 or 6 different sections of the code, and the entire thing probably ought to be rewritten. I mean, I would genuinely like for us to look at this over the summer, and those of us that are blessed to be reelected and come back down here, come with a clean bill. We looked at the history. We pulled that. Several of us had that emailed to us by historians. I think there is a significant rewrite that needs to be done. Trying to do this piecemeal is just not working. And so I had tried to put an amendment out there again that would have potentially helped with this bill. That apparently was not helpful. And so that's the reason I made this motion. But I do not want this issue to go away. In fact, I don't think it's going to go away. I mean, it's going to be an issue we need to continue to address. But it would be my intention that we rewrite the entire code in this area and not have this broken up by decades, by years, by sections. I mean, just have a nice, clean process that's out there, quite frankly, that's easy for everybody to understand, would be my preference.
By the way, our legal staff here has agreed, starting in May, to take all that code apart and clean out all the inconsistencies. And they said it would take about 2 months. And I was going to bring them a steak dinner during the middle of it, but they are going to address all that. Yes, sir. Representative Dixie.
Before you vote, and I appreciate everyone the consideration. As we did, we did the research and found out in 1986, they did make it a little easier for people to get their constitutional rights. So in 1996, that's why they brought it again. They brought it back, and the DA said, hey, we need a say in what's going on. It's too easy for people to do it. So this was doing exactly what the leader was saying, was going back and cleaning it up and making a uniform playing field for everybody. So I'm not saying this is a piecemeal thing, but I think this is something that we need to do. We keep kicking the can down the road. At some point, we have to get serious about getting people their constitutional rights back. Now, this is separate from voting rights, and I just want people to understand these are 2 different things that we're trying to accomplish here. And this is an opportunity to try to help people. And I took this job. I wanted this job because I wanted to help people. And we're in a position to help many people. And I really think that this bill goes back, it puts everything, it cleans up this particular code. It makes it a streamlined process for how to get your constitutional rights back. It doesn't make it easier. It makes it actually harder. And we're still saying, no, it's not enough. What is it going to take for us to do the right thing? How long do we have to keep going through this and killing bills and playing political football just because we don't want one person of a party to bring a bill that's going to help, that's really going to help? I'm frustrated because I brought this bill out of my heart to try to help. And every corner that I take, it's always political football, some kind of political aspirations in this. And it's frustrating. And I would hope that one day we can get to a point where we can actually legislate on the merits of the bill as opposed to the person who brought it.
All right, thank you. We got a motion in front of the committee. Senator Summer Study. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. Goes to summer study. Be fixed by this time next year.
I have no faith that it will be fixed.
It
period.
will be fixed. All right, that moves us back to item 3 on the calendar, which is House Bill 2865 by Representative Baum. You have a motion? You got a second? Representative Baum, you're recognized.
Thank you, Chairman Halsey.
I'm showing an amendment too. You?
Yes, it is amendment number 015749.
That's what I have. Is there a motion? Motion and a second on the amendment 015749 to attach to House Bill 2865. Okay, now you can proceed.
Thank you, Mr. Chair. Currently in Tennessee Code, a court with a criminal jurisdiction is eligible for grant funding for a veterans substance abuse court program through the Tennessee Department of Mental Health and Substance Abuse Services. This bill adds clarifying language. It says that if a court with this kind of criminal jurisdiction applies and is deemed to be have the capacity to provide a veterans treatment court program, then they shall receive funding from the Tennessee Department of Mental Health and Substance Abuse Services. And in this framework, the courtroom and the judge and the supplies will be paid for by the county. The grant money that would be provided by the department would pay for the program services, things like the substance abuse treatment, mental health treatment, and drug tests. And I'm happy to answer any questions.
All right, thank you. Any questions for the sponsor? Representative Davis.
Thank you, sponsor. I think this is an excellent bill, and I appreciate you bringing it. Do you know how many sort of courts this is in right now?
Yes,
Go ahead.
the last 3 fiscal years, there have been 5 or 6 counties that have received grant funding from this department. And those counties have changed a little bit over the 3-year period that I'm referencing.
Go ahead.
Thank you. I would like to see this expanded. I know that obviously it takes dollars to do that, but I think it's a very important and effective tool for the court system. So thank you very much for bringing this bill and this legislation. It's important.
Thank you.
Any other questions for the sponsor? Representative Hardaway.
Thank you, Chairman, and thank you for the bill, sir. I'm trying to understand what's different from the current status versus where the courts would be after this bill is passed.
The bill adds clarifying language. It changes the word may to shall, so that a court with a criminal jurisdiction that applies for the grant funding shall receive it. Doesn't specify the amount, but says that they will. And it also specifies that the funding isn't going to go to pay for the judge's salary. That should already be done by the county. The funding from the state should go to pay for these special programs like the mental health treatment or the substance abuse treatment, not for the courtroom. That's to be provided by the county.
And this is going to apply strictly to the state, not any of it. That doesn't prohibit the courts from pursuing other revenues.
I think that's correct. I think what the bill is trying to accomplish is it doesn't want the state to provide grant funding, and the grant funding goes to fund something that the county is already funding, like the courtroom and the judge. The grant money is supposed to go for some additional stuff, the treatment, the program, not to be used to fund what the county is already responsible for funding.
So it dictates it'll be supplemental as opposed to replacement.
I think so. It would go to fund supplemental programs, not existing capital expenditures.
All right, good bill. Thank you, sir.
Any other question for sponsor? All right, seeing none, we're voting on House Bill 2865 to go calendar rules. All those in favor say aye. All opposed, no. The ayes have it, sir. You move to calendar and rules.
Thank you all.
Indeed. Next brings up item number 4, which is House Bill 2611 by Chairman Zachary. You got a motion and a second, sir? You recognize. You got an amendment?
I do, Mr. Chairman. Drafting code 14460.
Okay, I got a premature motion and a second on that amendment. We will take it. Voting on 014460 to go to House Bill 2611. All those in favor say aye. Opposed, no. It's on there.
Thank you, Mr. Chairman and committee. Members, due to the multi-jurisdictional nature of human trafficking, this simply would allow law enforcement to present evidence to an additional DA if one DA refuses or declines to prosecute. This does keep Rule 18 in place in terms of venue. And this does, as the bill says, this does nothing to affect, impair, or limit the role, exclusive or absolute discretion of any district attorney general. So with that, I'll be glad to answer any questions.
Any question for the sponsor? All right, we're voting to send House Bill 2611 to calendar and rules. All those in favor say aye. Opposed, no. Ayes have it, sir. They say it's a rough committee. You better tread softly.
Thank you, Mr. Chairman and committee.
That brings us to item number 5, which is House Bill 2753 by Chairman Carr. You got a motion and a second, Chairman. You have an amendment as well. You have an motion and a second on your amendment. They don't even know the number, but I'll tell it to you. It's 017303. Is that what you're
correct.
showing?
Yes, sir.
All
Thank you.
right.
Thank you. And this is a.
Wait a minute. We got to vote on it. All those in favor of attaching 017303 to House Bill 2753, say aye. All opposed, no. See, you're going to have to hurry to beat me. Go ahead, son.
Thank you, Mr. Chairman.
Mr. Chairman, I think he's trying to retire
Yeah.
early.
Well, I got to get this bill through first. This is a reporting bill for the DAs, and we've worked with the DA conference on this, and they helped us with this amendment, and we're bringing it forth today. And what it does is just a report to let you know the arrests made and the offenses referred, the number of indictments filed, the number of cases transferred to another law enforcement entity, the number of cases which an indictment was sought, and the number of each disposition entered by the court. And with the DA's work on this and everything, the enacting clause on this does not go into effect till July 1, 2026. That gives them time to set up their database and everything so anybody can do a reporting on this. With that, sir, I'll stand for questions.
Thank you. Leader Lambert.
Sir, what year were you first elected to legislature?
2012.
You know, if you were elected to legislature in 2012, go ahead and raise your hand up in the area here. Come on, Gloria, join us here. All right. Look, there's some good 2012ers here, sir. We'll be sorry to see you go. I know that you're not running for reelection. By the way, there's still time between now and Thursday to change your mind on that. But if this were to pass, would it be your last bill on the floor?
I've got two. Well, it could be my last bill. I've got a couple more going through Finance, Ways and Means, but yes, it could be my last bill on the floor.
We'll be keeping an eye out.
Thank you, sir. Thank you.
Thank you, buddy. Appreciate
Thank
your
you.
friendship.
All right. We're Representative Hardaway.
Thank you, Mr. Chairman. I just want to know, if we hold this bill hostage, will it make you come back next year?
Well, I appreciate that. You could hold this hostage all you want, but when it would be one of those we call Mexican standoff, we wouldn't get anywhere. I can tell you that. I'd have to stay home.
Well, I've enjoyed working with you, sir.
Thank you, sir. Me too.
Hate to see you go. Thank you, Chairman.
Yes, Representative Towns.
Once you leave, your honeydew list goes from this to like that.
Thank you, Representative Towns. I'm already experiencing that when I go home now on weekends. Because now, to be honest with you, she's with my mother right now, and she's taking 4 days a week that she has to stay with her. She's 90-year-old, and so when I go home and get this all settled, we'll be taking time. And we have lived with my mother ever since last April, so it's just time I go home and take care of business.
Absolutely.
Thank you.
Godspeed, brother. Godspeed.
Thank you.
All right. We are voting on House Bill 2753. All those in favor say aye. Opposed, no. Ayes have it. Moves to calendar and rules, sir.
Thank you. Appreciate you, Chairman and committee. Thank you. Thank you. Thank you.
That brings us to item number 6. We have a motion and a second on House Bill 2790 by Chairman Littleton. You are recognized, ma'am.
Thank you, Mr. Chairman. And it does have an amendment, 15108.
I got 15108. Is that what you said? Okay, you have a motion and a second. We're voting on amendment 015018 to go on to House Bill 2790. All those in favor say aye. Opposed, no. Ayes have it. It's on.
Thank you, Mr. Chairman. This clarifies, of this bill as amended clarifies that an existing Class B misdemeanor offense for knowingly tampering with, removing, or vandalizing a monitoring device ordered or as a condition of bond applies to an alternative monitoring device so ordered, creates a Class B misdemeanor offense for a person released on probation or parole to tamper with such a monitoring device, or for a person to aid, abet, or assist the offender in the such tampering, establishes that if the person ordered to wear the GPS device tampers with the device, to the extent that the device is damaged, the offense may be punished by a Class A misdemeanor offense for theft. Requires an entity monitoring such devices that becomes aware of such tampering to promptly give notice to the violation to the probation officer or the Department of Corrections.
Any question for the sponsor? Seeing none, we're voting on House Bill 2790 to go to calendar rules. All those in favor say aye. Opposed, no. Ayes have it. You move to calendar rules.
Thank you, Mr. Chairman and Committee.
Brings us to item number 7, which is House Bill 2386. Where'd the sponsor go? Oh, right there you are. Okay, I'm sorry. And you were recognized, sir. You have a motion and a second.
Thank you,
And
Chairman.
I'm showing an amendment on that as well.
015892.
That's right. Motion and second on amendment. We're putting amendment 015892 onto House Bill 2386. All those in favor say aye. Opposed, no. Ayes have it, sir. It's on.
Thank you, sir. I'll be brief. I know most everybody's heard this bill and its full description, so I'll be brief, and then I'll be glad to answer any questions. Over 300 Tennessee citizens are killed every year by alcohol and drug-impaired drivers. Because evidence of alcohol and drugs metabolizes and dissipates from the bloodstream quickly, this bill makes multiple changes to existing law that will provide for a timelier and more efficient collection of blood evidence to support the effective prosecution of DUI, vehicular assault, and vehicular homicide offenses. And with that, Mr. Chairman, I'll be glad to try to answer any questions. And if I can't, we have the DA's conference here as well.
Any questions for the sponsor? Leader Lambert.
Mr. Chairman, and to the sponsor of the bill, thank you for bringing this. And I want to publicly thank Norris Skelly for his work with Motor Students Drunk Driving. And Norris has been one of those guys that if you don't know him, you need to get to know him. I mean, he's just a phenomenal fella. And so, Representative Gann, I know that, you've worked with him on this bill and with others, but it's just, there's some real unsung heroes down here, and I just want to give him a shout out. Thanks.
Okay, any other question for the sponsor? All right, seeing none, we're voting on House Bill 2386 to go to calendar rules. All those in favor say aye. Opposed, no. Ayes have it, sir. Moves to calendar rules.
Thank you, Chairman and Committee.
Brings us to item number 8, which is House Bill 2471 by Representative Raper. You have a motion and a second, and I'm showing 2 amendments. Is that right, sir?
Yes, sir.
You want to put both of those on?
Yes, sir, please.
I'm showing 015109. You got a motion? Got a second? We're putting 015019 on 2471. All those in favor say aye. All opposed, no. Ayes have it. That one's on. The next amendment is 016771. Got a motion and a second. All those in favor say aye. Opposed, no. And we will roll both of these amendments together into one without objection. It's too
Yes, sir.
late now. All right. Representative Bravery, would you like to present your bill?
I would. Thank you, Mr. Chair, and thank you, committee. The purpose of this bill is to give latitude for judges to transfer 16 and 17-year-old adults to adult court under certain conditions. And this is an and statement. First of all, the juvenile must be 16 or 17 years of age. The second one, part of the and statement is must be the juvenile's second or more offense of criminal gang activity. And the juvenile judge still has a prerogative to not transfer if they see the rehabilitation is working. So they still have that prerogative. And one other thing about the Second Amendment is this. It states something that to the effect of in in a case where someone is transferred and there is not room in the adult juvenile or the adult facility, then they will not transfer. The Sheriff's Association asked me to put that one on there, and they decided to endorse the bill. So thank you. At this time, I'll entertain any questions.
Thank you, Mr. Sponsor. I want to tell you, I got some problems here. One is the Second Amendment issue that you bring up has already been passed in a bill that we ran through this committee with Chairman Grills. But more than that, your bill creates a conflict in the code. Already, 14-year-olds and up can be referred to a juvenile court for the crimes that you got listed, almost every one of them. You might have one or two more in there. Your bill says 16 and up for these same crimes, which of course presents a big conflict in the code. How do you respond to that?
Most of them are covered, but there are 4 or 5 that are not covered under this, and I'm of the opinion that the juvenile judge is the best person. They know the background and history and the rehabilitation's done. So they would be the ones that, under those small amount of conditions that they usually don't transfer them on, that they would be the best ones to make that decision. So.
Well, they'd be the best ones, I guess, to deal with the conflict.
Yes, sir.
I don't know that you got an answer for it. Any other questions for the sponsor? Representative Towns.
Well, Mr. Chairman, with that, to me, we have lawyers here and folk that are, real learned in this area. But if this will change the law, certainly. So I would think that the old law would not apply. Would it not? That's because it'll take the age from 14 to 16. Is that correct, legal?
Would you like to ask legal?
I'd love to. I thought she was your chairman. Please.
Michelle Fogarty, Office of Legal Services. So the provisions about juveniles 14 and up would still be law. There would just be a provision that says if you're 14 and up and charged with murder, aggravated rape, and a lot of other offenses, that you can be transferred. And then this section would also say for a second or subsequent criminal gang offense, which could include some of those same offenses, that you can also be transferred. So it could cause confusion. But that would be for a court to decide. But this bill does not delete the current language
Got
about
it.
14-year-olds.
And that's what I thought. Thank you. That's what I'm looking for. Okay. Thank you, legal, for that.
Any other question for legal?
Yeah.
While we're out, Representative Hardaway.
Thank you, Chairman. And I certainly support the bill. That's for the sponsor. But for legal, are we adding a second option on what offenses you can be transferred to adult court on?
Shouldn't be either or.
Michelle Fogarty, Legal Services. It's adding a provision that is specific to juveniles who are 16 years of age or more at the time of the alleged conduct. It's adding that any 16-year-old who is charged with a second or subsequent criminal gang offense would be eligible for transfer. And then it references a definition of criminal gang offense in Title 40.
So we're just adding to the offenses, but we're only adding to the offenses for 16 and up that are eligible for transfer to adult court.
Yes, but some of those same offenses are already eligible for 14 years of age and up. The bill references a definition for criminal gang offense in Title 40, and that definition includes numerous offenses, many of which are already eligible to be transferred if the juvenile is 14 years of age or more.
Okay.
On the first offense.
I'm sorry. Go ahead, ma'am.
The 14-year-old, they're already eligible if they're 14 and up for they first violate a first offense. as opposed to a second or subsequent.
Can I inject right here, Representative Hardaway? That was another conflict that in the existing law on the first offense, you can run a 14-year-old up. Under this bill, it takes the second offense for a 16-year-old. That's the kind of conflict that I wish the sponsor would get fixed before we run it. Leader Lambert?
Are we back in session at this juncture?
No, sir.
May I make a motion to go back into session if you can come back to me after that?
Representative Hardaway, do you have any other questions for legal?
No, sir.
Okay, any other question for legal? All right, we're back in session. Leader Lambert?
Mr. Chairman, we're still going to meet next week. What I would make a recommendation, since the chairman's brought up several good points here, I'd make a motion that we roll this 1 week, give the sponsor a little bit of time to work on whatever issues that are out there. I still feel confident there's probably a way to get a bill that would work here. But Mr. Chairman, if you're concerned, we're concerned. So I'd make a motion to roll 1 week.
Okay, there's a motion and a second. All in favor for rolling a week, committee rolls, say aye. All opposed, no. All right, roll for 1 week, sir.
Yes, sir.
Brings us to item number 9, which is House Bill 2475, also by Representative Raper. Is there a motion? Got a motion and a second? Sir, you're recognized, and I think I got an amendment on that too.
Yes, sir.
Are you showing 014597?
I am. Yes, sir.
Is there a motion? Motion and a second on the amendment. All right. I said all those in favor say aye. Whack the bill. Here we go. All right. The amendment is on the bill, and you can proceed, please.
Thank you, Mr. Chair, again. And this bill pertains to truancy in juvenile court. The court has already filed an unruly for excessive truancy. Many of these students provide a large number of medical release forms, which we refer to in the educational field as doctorate notes, which a school must accept based on current law. In many of these situations, the court would like more information or explanation. And upon request from what we refer to as campus court, but I think in law it's referred to as teen court, the doctors would be required to provide the requested information. Also, I'll say this bill will assist principals, assistant principals in obtaining pertinent information without violating the HIPAA law, because it would still stay within the teen court. The only thing they would know is what verdict would be rendered at that point, as far as the principals, assistant principals. It will accomplish it without adding any additional burden to a juvenile judge, which was only before that accomplished by a subpoena. And this bill will possibly correct many chronic absentee issues by being solved through teen court rather than reaching a juvenile judge. So I stand for
Okay.
questions.
Makes sense. Any question for the sponsor? Vice Chairman Gillespie, I'm sorry.
Thank you, Mr. Chair. And this is, I guess, kind of an embarrassing question. I just need some clarification either from you or from legal. I'm not familiar with the teen court. I don't know if that's something that Shelby County even has, or if it's just my ignorance, but.
Go ahead.
It's my understanding as a former educator that every place in the state of Tennessee does not have this, but it's an extension of juvenile court, and they hold it on site. And then what they do is they try to render verdicts and offset it getting all the way to juvenile court. And it's ongoing. So, but everyone in the state doesn't have this. So.
Any other questions? Any other question for the sponsor? All right, seeing none, we're voting on House Bill 2475 to go to counter the rules. All those in favor say aye. Aye. Opposed, no. Ayes have it, sir. Moves to counter the rules.
Thank you, Mr. Chair and committee, both times.
Thank you, sir. That brings us to item number 10, which is House Bill 2460 by Representative Vital. You got a motion and a second. You recognize, sir.
Thank you, Mr. Chairman. Thank you, committee. On behalf of House Bill 2460, this legislation seeks to amend existing law to allow cooperatively owned insurance companies to pursue restitution from convicted persons that have harmed their subscribers of the local cooperatives. This bill is brought to me on behalf of the Tennessee Electric Co-op Association, And let me just basically tell you why we need to determine cause with regard to fraud and restitution. A local co-op had an employee who embezzled $150,000. They were convicted. They were brought to justice, charged in court. Our co-ops use a pooled insurance entity, which is owned by the local co-ops, to make them whole. And in this case, they went to court to pursue restitution. And we found that they did not have cause and standing in the case. This would simply allow them to pursue restitution as the co-op insurer and then ultimately protect the members who ultimately are the owners. So I'll be glad to take any questions.
Okay, thank you. Chairman Doggett.
Thank you, Mr. Chairman and sponsor. Would you say that this legislation is vital to the cooperatively owned insurance companies to seek restitution?
Thank you, sponsor. In my humble opinion, I think it is on behalf of the co-ops.
Thank you.
Leader Lambert.
Move previous question.
Previous question been called. We're voting on House Bill 2460. All those in favor say aye. Opposed, no. Ayes have it, sir. Moves to counter the rules.
Thank you, committee.
Brings us to item number 11, which is House Bill 1827 by Representative Martin. Sir, you are recognized with a motion and a second. I'm showing an amendment.
Yes, Chairman. Amendment number 014156.
Okay, you have a motion and a second on 014156 to go on to House Bill 1827. All those in favor say aye. Opposed, no. The amendment is on. Proceed, sir.
Thank you, Committee and Chair. This bill was brought to me from a senator over in East Tennessee from his juvenile court judges. Currently, there's a threshold to retain juveniles that are chronically running away, and that's 24 hours. This would allow that process to go from 24 to 72 hours in extreme rare circumstances. Juvenile courts requested that to help because what we've seen across, and especially in East Tennessee, has been an increase in drug abuse, and some of these individuals are coming back with while still detoxing as they go back into that center. So this would allow them to have that opportunity to hold them a little longer in specific cases. With that, I stand ready for questions and humbly ask for a favorable vote.
All right, Representative Johnson.
Thank you, Mr. Chairman. And I want to thank you for running the information that we talked about, the question we had. I appreciate that. And I guess I still, just because it's sort of sketchy to me, it still makes me concerned about losing that $1 million of funding. So even though I appreciate where you're headed, I am concerned about losing that money that's $1 million for prevention. But thank you.
Thank you.
Any other question for the sponsor? All right, we're voting on House Bill 1827 to send to Finance, Ways and Means. All those in favor say aye. Opposed, no. The ayes have it. If you want to record as no, please see the clerk, and you move to Finance and Ways. Brings us to item number 12, which is House Bill 2466. You have a motion and a second, Representative Stevens, and I'm showing an amendment.
Yes, 14709.
That's what I show, and you got a motion and a second. All those in favor of 014709 going on House Bill 2466, say aye. Opposed, no. Ayes have it, sir. It's attached.
Thank you, Mr. Chairman. This bill authorizes the TBI to inform the District Attorney General for the Judicial District if someone has been granted a prior expunction. And it also allows a court clerk to release that person's order of expunction to him or her if he or she loses their order.
All right. Any questions for the sponsor? Any comments for the sponsor? All right. We're voting on House Bill 2466 to go to counter rules. All those in favor say aye. Opposed, no. Ayes have it, sir. Move to counter the rules.
Thank you, committee.
That brings us to House Bill 2820 by Leader Camper. You got a motion and a second, Leader.
No amendments. No amendment.
Sorry.
All right. Leader, you are recognized on House Bill 2820.
Thank you, Mr. Chairman and committee. I was trying to get some water. Members, What this bill would do is, 1 minute, Mr. Chairman.
Right now. Leader Lambert.
Move previous question.
That's not debatable, isn't it? We got a motion to move previous question. We're voting on House Bill 2820 to go to Finance, Ways and Means. All those in favor say aye. Aye. Opposed, no. We're hungry too, ma'am.
Thank you, leader. Thank you all. Thank you, committee, for doing your due diligence. Thanks, leader. Jesus, thank you.
That brings us up to item number 15, which is House Bill 2223 by Representative Love. And I'm showing amendment, sir.
Yes, sir.
You do have a motion and a second. This is amendment 015559.
Yes, sir.
Got a motion and a second. All those in favor attaching 015559 to House Bill 2223 with love, say aye. Opposed, no.
Attach it with
The
love.
amendment is attached, sir.
Thank you, Mr. Chairman and members. This piece of legislation, very simple. It expands the age from 21 to 25 for those who would be able to qualify as missing. We have a lot of people who are missing, and in that age range, they oftentimes don't get the attention they need to have. And I think in the subcommittee, the question was asked, would this have possibly helped the young man in Nashville that was missing? It would have, because at age 22, there may have been more of a response if he had been up under this particular law. So that's what it simply does, and we just have some information there that hopes will get out to people through media and through technology to get more information around people who are missing.
Okay, any question for the sponsor on the bill? Representative Hardaway.
Mr. Chairman, I applaud the sponsor for the bill and would just comment that this is keeping in line with the new medical neurological research. Thank you.
All right, any other questions or comments for the sponsor? All right, question been called. We're voting on House Bill 2223 to go to calendar and rules. All those in favor say aye. Aye. Opposed, no. Ayes have it, sir. Moves to calendar and rules.
Thank you, Chairman and committee members.
Brings us to item number 17, which is House Bill 1878 by Representative Freeman. Leader Lambert.
Mr. Chairman, I don't see him. I am on the bill. I'll run it if, Mr. Chairman, if you want me to, but.
Well, I would just go for it then. Do we have a motion and a second? You have a motion and a second. I'm showing an amendment.
017068, Mr. Chairman. I would move that
Correct. You
amendment.
have a motion and a second on that amendment. We're voting to attach 017068 to House Bill 1878. All those in favor say aye.
Aye.
Opposed, no. Ayes have it. Please proceed.
Thank you, Mr. Chairman. I signed on to this bill because it amends and increases from $1,000 to $2,500 the maximum allowable compensation amount that may be paid to a healthcare provider for performing a forensic medical examination on a victim of sexual assault. It's what you will hear commonly referred to as a rape kit. It is, to me, incomprehensible that any victim of sexual assault in this state would ever have to pay any amount of money out of pocket for an examination that was necessary because of an assault on that person. And so with that, Mr. Chairman, I stand ready for questions.
Any question for the sponsor? Chairman Doggett.
Thank you, Mr. Chairman. And I can hold my question for you and ask it to the original sponsor, or?
No, let's just let him observe.
Mr. Chairman, who would you like for me to ask this question?
Address it to the sponsor of the bill who's on time.
Hold on. Don't go nowhere. No, my question was this, and it was brought up in the subcommittee in some passing conversation, but and I'm sure the leader's extremely going to be adequate in answering this question, but I think this bill would refer to an instance where an individual would go to maybe a hospital or a clinic or something after a rape that would get these rape kits, not one that would go to law enforcement. My question would be if they did go to a hospital and law enforcement would be notified, would law enforcement then come in with their own kits and would they be processing this, or would this be something that the hospital would still go through with?
Mr. Chairman, I'll begin and then I will relinquish and tender to our now present sponsor for the bill. I asked that very question to some folks that were in my office that were advocating for this bill, and the answer was it depends. It entirely depends on the circumstance and situation. It depends on when law enforcement got involved in the case. It really depends sometimes even on the medical provider. But it just depends. And to me, that was not a sufficient answer for a victim that has already been through something incomprehensible and horrible. But if there's ever a circumstance that someone would have to pay out of pocket for an examination of this nature, then to me, it was a bill worth passing. But again, I'll tender to my friend from Davidson County who actually brought the legislation and is now actually present. He does appear not to be out of breath. He's composed himself. That's the best answer I can give, having not been the prime sponsor, but I am glad to be a co-sponsor.
Go ahead.
Thank you, Leader. I agree. It depends. The majority of the times, this is a direct compensation for hospitals and nonprofits. There are instances where you have law enforcement that it's their kit, but the majority of the time it's a nonprofit or a hospital.
All right, any other questions?
I do, if you don't mind.
Go ahead.
At any time are these victims told up front that this is what you've got to pay for us to process this, or is this a reimbursement to the hospital or facility that's doing that?
No, it's always assumed that the cost is going to be covered.
Okay, good. I'd hate for, I just think that it would be extremely unfortunate for someone to be told that there's a cost that you must incur up front before this. So thank you for this bill.
All right, any other question for the sponsor? Representative Towns.
Thank you for the bill as well. Question is that if the nonprofit performs it, who eventually gets the data? Does it go to the police at some point to be housed and staged for future prosecution?
Go ahead.
Yeah, absolutely. So once it's it's a forensic test. So the nonprofit hospital doesn't own that test. The law enforcement actually owns that test, and so it goes to them for the process of a forensic test.
Any other question for the sponsor? Chairman Lowe or Russell.
Thank you, Mr. Chairman. And after the tests are complete and the results are back, does the TBI store these, or anybody store these tests, or do they destroy them, or what happens to them?
Go ahead. Yeah, they actually keep the test, and once it goes through the testing process, it's run through CODIS, and then it's in a national database.
And will this cover the storage of the test?
So this is exclusively for the medical procedure for the testing, taking the test.
Very good. I'd like to sign on to your bill. Thanks.
Thank you.
Any other questions for the sponsor? Representative Davis.
Thank you, sponsor. And so can you go through that chain of custody for me again, for if it's not in the hospital, if it is a independent thing, can you explain that to me again? I didn't catch all of that. Thank you.
Sure. Thank you for the question. So the test is actually given from the TBI to the nonprofit or the hospital. The hospital takes the test. Law enforcement, if it's an active test versus a hold kit, law enforcement takes the kit from there back to TBI for testing, and then it's run through CODIS.
And so the nonprofit would then notify law enforcement that they were taking that test to have the law enforcement come and pick up that test, or does the nonprofit then take it to TBI? How does that work if it's not a hospital situation?
It's exactly the same process. Hospital, nonprofit.
Okay. So they would notify law enforcement. Law enforcement takes it to TBI.
If the victim decides to notify law enforcement, yes.
Okay. So if she was taking the test, why wouldn't she want to notify law enforcement? Why would she take the test and not notify?
Yeah, that's a great question, and I'll defer to leader, and then I'd love to speak on that.
Okay, thank you.
Leader.
Again, just from almost 20 years of operating the court system, there are many times that when someone has been violated in this way, in the statute, as we were just going over a second on the sidebar over here, it doesn't require notification because there are times when someone has been traumatized and victimized so much that it will take time for them to be at a place where they feel comfortable and safe coming forward, and even cooperating with law enforcement or reporting in any way. And law enforcement is trained to meet victims where they are, and then lead them through the process as best they can. But it really tries to put the power in the hands of someone who's been victimized here, so that the timing of that. Just a couple of years ago, I had a young lady that came into my office, and it had been a couple of years since she had been assaulted, and she had not felt comfortable coming forward. She did not feel safe. And she asked at that time whether we could try to track down her rape kit, and we were able to do so. And it did not result in a charge, but she wanted to know what happened with that, what occurred, and then she had the ability to make a decision on how to go forward. And so it just tries to put the power into the hands of the individual who has been victimized in a way that most of us can never truly understand.
Yes.
So that preserves then that evidence. So then you can determine, or that victim can then make that determination whether to move forward or not.
Sure.
And how long is that storage of that rape kit? Do you know?
Yes, sir.
Thank you, Chairman. So it's 10 years, and I want to add one more thing. The idea that the majority of rape cases are somebody jumping out of the woods and doing this is just not true. The majority of the times, it's somebody that you know, it's a family member, it's somebody of power. So allowing the victim the time to process this, but also preserving the evidence is extremely important.
Representative, I'm sorry. Representative Towns.
Well, Mr. Chairman, based upon what the leader stated, years ago, because of what the leader stated, I passed a bill that will allow for a person that's been raped 3 years before they can even, if they want to wait 3 years before they decide to process it and tell it. And at that point, if they catch them 25 years later, they still can be processed. So in fact, de facto, it kind of took the statute of limitation off of it. We did this probably about 15 years ago, passed a bill that would address this kind of situation because people need time to decide what they're going to do, depending on who it is and, just how traumatic it was, it is, and so they have time the women in Tennessee have the time to do it. So thank you for the bill. I too want to sign on your bill.
Thank you.
All right, any question for the sponsor? All right, seeing none, we're voting on House Bill 1878 to go to Finance, Ways and Means. All those in favor say aye. Opposed, no. Ayes have it, sir. You're on
Thank
your
you,
way to
Chairman of the committee.
Finance, Ways and Means.
Thank you.
Brings us to item number 18, which is House Bill 2572 by Representative Parkinson.
Thank
You
you.
got a motion and a second. You are recognized, sir.
Thank you, Mr. Chair. This bill expands the offense of aggravated rape to include when the defendant commits rape knowing that the defendant is infected with HIV. With that, Mr. Chair.
Any questions for the sponsor? Leader Lambert.
Thank you. I noticed the Senate amendment is slightly different on this, and I think I asked this in sub as well. Can you give us, and I trust your word explicitly, give us your word, just stick with the House version on this one?
I'm standing on business, Mr. Leader.
Thank you very much.
Keeping this amendment.
Yeah, it got weakened in the Senate, and yours is much stronger, so thank you.
Thank you.
Representative Johnson.
Thank you, Mr. Chairman. So with treatment for HIV now, you can be getting treatment and not be able to transmit the disease. So if someone is not able to transmit the disease, I mean, we're talking about rape, I get that. But does that matter or not matter? if they're unable to transmit the disease.
And thank you, Representative Johnson. Remember that it's starting on the basis of rape. The fact that someone forcefully raped someone, and so that's our foundation, first of all, and secondly, whether the infection is transmitted or not, that individual is still living their life, looking over their back, wondering whether or not that this infection is going to come up on them or not. Sometimes, and from my understanding, the infection doesn't show up immediately, but that person is still living their life wondering if they've been infected or not. And so we don't know if there's no guarantee that they're going to be infected or not.
I guess, but the perpetrator does know if the treatment has been successful and they are not able to transmit. I guess that's my question.
Go ahead. And my only response, respectfully, is that perpetrator also knew that they were HIV positive, but they didn't disclose that either. And so that's my
Okay.
Yes, ma'am.
All right, any other question for the sponsor of the bill? Representative Hardaway.
Thank you, Chairman. Sponsor, are any other diseases that can be contracted by sexual intercourse carry the same penalty or similar penalties?
Go ahead. Thank you, Mr. Chair. And Mr. Chair, if we can, so that I can give an accurate answer through legal, if we can go out of session and allow legal to answer that question, I'd be appreciative.
I'm good
Okay,
with that, Mr. Chair.
that's a request. Out of session for legal.
Michelle Fogarty, Legal Services. The answer is no.
So no other diseases are covered under this nor under current law with the same conditions and penalties.
For rape or aggravated rape, no. No, sir.
All right, thank you.
Or any other question for legal? All right, we're back in session. Leader Lambert.
Mr. Chairman, I do want to say, and the sponsor kind of alluded to this, and we're talking about rapists here. If they're convicted of rape, then they ought to be in prison as long as we can possibly keep them. And if they have this particular disease, then it's an enhancement. I mean, it kicks it up, I think, from a B felony to an A felony, and it's just going to keep a rapist in prison a little bit longer based on this enhancement. So if a jury or a judge finds that beyond a reasonable doubt they're guilty of rape and they were HIV positive and knew it at the time, then they ought to rot in prison for the rest of their life, for all I'm concerned. But at least as long as we possibly can, because again, it's a horrible crime. So that's just my opinion.
Representative Hardaway, did I cut you off?
Yes, sir, but I don't mind being cut off for the wisdom of the leader. I always learn something from it. But I would say that my problem with the bill, sponsor, is that it stigmatizes HIV/AIDS. If the bill included all of the diseases which could be transmitted, I'd be 100% with it. But I've spent years in working with the HIV/AIDS community, trying to destigmatize it so that it can be, there can be an educational process which leads to treatment, and which leads to the acceptance for some back into their community, family, friends, etc. And I'm really locked in on this because I've had over the last few years, it could be post-COVID, but I've had folks come to me and say, hey, that testing that you did with the preachers, testing that you did with law enforcement, with the police department, sheriff's department, elected officials, that gave them the courage to come forward. And in spite of at that time, the stigma that was associated with one disease out of many, which could threaten the health of an individual. So my only problem, of course, I think rape is a abhorrent occurrence. And if I had my way, I'd do twice as much as what Leader Lambert would do. And you know what he would do. So that's the only problem I have, is that by taking one disease, one type of infection, that we stigmatize it again, because that's what we're trying to get away from. And I don't know whether the leader has said that you've got to commit to accepting no amendments, or whether he said he just doesn't want it weakened. But I would feel more comfortable if we had things like hepatitis and some of the other diseases included. Thank you, Chairman.
All right, any other question for the sponsor? Representative Towns. Question been called on the bill. We're voting on House Bill 2572 to go to counter the rules. All those in favor say aye. Opposed, no. Ayes have it. If you wish to be raised as a no, see the clerk. You move to counter the rules, sir.
Thank you, Mr. Chair. Thank you, committee.
Brings us to item number 20, which is House Bill 2301 by Chairman Howe.
Motion.
You have a motion and a second, and I'm showing an amendment, sir.
17327, Mr. Chairman.
That's what we got a motion and a second on the amendment 017327 to go to House Bill 2301. All those in favor say aye. Opposed, no. The ayes have it. It's attached, sir. Proceed.
Thank you, Mr. Chairman. This bill deals with the sale of fentanyl or any derivative or mixture thereof. The criminal code is, the current criminal code rather, is 3913210. It allows a district attorney to charge a drug dealer with second-degree murder when an overdose occurs from drugs that he has sold to an individual. They're doing that now. But there occurs sometimes confusion with juries when they're charged under the criminal code and drugs are involved. So what this bill does is simply take the language in that section of the criminal code and puts it in the drug code section, 3917-417, which addresses the selling of drugs. And by adding that language to the drug code, it makes the prosecution of a dealer who sells fentanyl resulting in death much less confusing to a jury and a cleaner prosecution. And it also gives the DAs more discretion. So with that, Mr. Speaker, Mr. Chairman, I move passage.
All right. Any questions for the sponsor of the bill? Seeing none, we're voting on House Bill 2301 to move to Finance, Ways and Means. All those in favor say aye. Opposed, no. Sir, your bill moves on.
Thank you, Mr. Chairman.
That brings us to item number 21, House Bill 2601 by Representative Johnson. Got a motion? You got a second? You recognized.
I suppose since this bill was murdered in the Senate, I will have to take it off notice.
Okay. Without objection, the bill goes off notice. Which brings us to the end of our calendar. It is a happy, happy day. If there are no other business for the committee, do I hear a motion to adjourn? We are adjourned.